You are mom.
I know,
Okay, thank you so much for coming.
absolutely.
Mr. Patrick, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on April 7th, 2025 in Harris County, Texas, officers were dispatched to a burglary of a motor vehicle call. The defendants were located and matched the description the complaining witness gave to the officers. The complaining witness stated defendants entered the vehicle and tried to steal it by breaking the ignition cover. The complaining witness stated her neighbor was leaving for work and it scared the defendants off. The defendants left a screwdriver in the motor vehicle. The complaining witness stated the ring camera caught the incident. Co-defendant was found to have 2 key fobs on his person, individuals. A screwdriver and gloves were found in the defendant's backpack, and a ski mask was found on the co-defendant's person. The defendant provided false information, and the defendant was eventually identified by mobile AFIS.
There's so many holes in this thing. I mean, how do we know it was him? Was he in the car? Where did they catch him? Did they go running after him? I mean,
Judge, if I can just.
it's a complete disjointed. Submit now.
Judge, the law enforcement officers were dispatched and were given a description of 2 individuals by the complaining witness who had it on a ring camera of the individuals breaking into a vehicle. And
Do they see him? Does the report say that they saw Mr. Patrick?
just a description given, Judge. And then the law enforcement officers on dispatch located the 2 defendants nearby.
Does it say that there, or are you assuming?
Sue Burley, they advised the last direction of travel being east of the residence and northbound intersection of Maryland. After a brief search, both defendants were obtained on foot, matching the description provided by one complaining witness. The complainant advised that they made entry into a vehicle and advised they attempted to steal the vehicle by breaking the ignition cover. Due to a manufacturing flaw, upon exposing the ignition, the vehicle can be started without the ignition key. The complainant advised her neighbor directly across was leaving for work, and both defendants began to leave on foot when they heard noise. And then they found a screwdriver was found on the vehicle floorboard. The complainant advised that her doorbell camera captured the incident and provided a positive description of both suspects, both being males wearing dark hoodie sweaters, black pants, both slender in build and being tall, and the one being tall and being short. After a pat-down search of the defendant, defendant 2 was found to have 2 key fobs stuck into his pants, and one fob belonged to a Dodge that was connected from another burglary of a motor vehicle. That was not the charge you'd be here, Judge.
Is Mr. Patrick defendant 1 or defendant 2?
He's defendant 1, Judge.
He doesn't have the key fob. It's the other gentleman.
That's correct, Judge.
He's the one that has the stuff in the backpack.
Just want to verify that, Judge. That's correct.
Patrick, I'm going to find that there's probable cause to go forward with your case. You live in Houston, dude. You don't live in another state. People like their guns and they like their cars. And when you mess with the wrong person, they're going to shoot your ass dead in a heartbeat to keep what's theirs. How many countless stories do you hear of someone running away from one of these types of situations? They get shot in the back. It's only a matter of time. Was this in the middle of the night?
It was early in the morning, Judge, around 6 a.m.
Patrick, I'm going to find that there's probable cause to go forward with the case. I am now going to put a whole host of conditions to make sure that you do not fall through the system or the cracks, because we don't need another statistic or we don't need another person dead. Do you understand me? The first is that you are not to hang around with the co-defendant in this case. You are not to use alcohol, illegal drugs, and I'm going to send you for a test right now because I want to know what, if anything, is in your system and you're to come right back. Do you understand? If you fail the test, if you fail to come back, it's not going to go well for you. I'm now also going to put a monitor on your ankle so I know where you are at all times. One false move, you will stay with me. I need your help, Mom. I can't do this alone. You and me together, we can make this thing work. Tell me about him. What does he do? Is he in school now?
Well, I did have some in school, so he did go to school, but
Okay.
I see high school.
Wonderful.
He did have sign up for a job, so he was looking for a job, so he do have a job.
Well, what I was going to do is I was going to order him and only give him time so that he can go to school, and then he goes back home. And then he stays at home, doesn't go anywhere else. I don't want him out in the middle of the night. You're not to be in possession of any weapons as well. If I find that you have any weapons, if I find that you pick up a new case, it's not going to go well for you. I will protect my city at all costs. I don't care what you are, how old you are, anything. Do you understand? We will work with you to make sure that everything works together. I'm going to pay for everything so you won't have to pay for anything. I'm going to give you a lawyer today. So we just need to know what schedule. Do you work?
I work Wednesday through Saturday,
And then you're out.
then I'm off.
I mean, you're out like out working. My only fear is that when the cat's away, the mice will play. So that's why while you're at work, he stays at home. I'm going to test you like crazy to make sure that you're not using anything. Do you understand? You must stay in school full time. The GPS monitor will tell me where you are at all times. And if you leave school, try to skip class, I'm gonna skip your bond. Do you understand? Okay, shoot.
So, just a couple of years on, so him that, don't have a country right now, because he's not going to work for him. So, yeah, I wish he said,
Okay, so let me get you a lawyer. We got to figure out a schedule because I don't want him out just hanging around and doing whatever. If he gets a job, then we can work with a schedule. But other than that, I probably just got to stay at home. You know, I don't want him out just screwing around because, you know, okay, we'll work together. You must listen to Mom. If Mom tells me that you start acting like a knucklehead, you will stay with me and you will earn your degree with me behind bars. Do you understand? If she tells you to jump, you ask how high. Do you understand, Mr. Patrick? Okay. All right, Mom. Please, and just hang tight and then we'll hook you up. Hey, who's teaching?
Judge Escamilla, he's here. He went for a drug test.
Come up, Miss Escamilla. I guess Roxanne's not here.
She said that. So she did tell me alcohol or THC.
He's still using. Unacceptable. I mean, it's been, I tested you once, you test positive, you test it again, you're still testing positive.
Judge, do we know the quantities and is it just THC? My client says he has not been smoking and I don't know how long it takes for it to come out of his system.
This case has been open since 2022. He's multiple times failed to appear. I've asked him to continually comply with bond conditions and you've continually over and over and over and over failed to comply. Now your case is 1,010 days old and you continue to test positive. Right now, you're going to jail. Goes with you. Unacceptable, Mr. Escamilla.
Your Honor, I've not been using.
Test says otherwise. And now at 1,000 days old, multiple tests, you stay with me.
Judge, and to be clear, I just got appointed last time. I haven't been on this case for 1,000 days.
You're
So,
not the first lawyer on this case.
I know, but
And at some point, we have to say when, but it's unacceptable that being 3 years old and now it's over and over.
I think the issue is, Judge, he smoked before the last appearance when he was brought in on the warrant, because he's brought in on a warrant on the new charge. And I think that's the issue. I truly
Even if
do.
it's
And so-
on the time,
I know, Judge, but just for me to advocate
I get it.
completely for my client,
I'm
I
not,
know he was on a warrant. I know that he was on bond for that first charge too, but I think it didn't really sink in until the second one. And I've been in contact with him. My staff's been in contact with him. He's trying this time. So what's
no, and he's going in.
what's the new bond? I'm appointed judge.
I get it.
I know, so he can't, I
Tell
know,
him that we mean business.
I know, Judge, I'm just
First case is
advocating.
at 5,003, so I'll set that at 7,504 and then 5,001 on the failure to ID.
Say that again, Judge, I'm sorry. And that's my hearing issue.
So the failure to ID is set at 1,000.
Okay,
So on that one, I'm gonna do 5,001.
okay. And then the old case,
The old case is at 5,003, so I'll do 7,504.
7504. Thank you, Judge, I'll go talk to him.
So the agreement that you guys have worked out is both, he's got 4 open cases?
He has 4 open cases, Your Honor. The agreement that we worked out was a time served on the failure to ID and the latest criminal trespassing, and they're dismissing a criminal trespassing and interfering with it.
Why, you need to understand something, that you guys can work something out. I don't have to accept the deal. And I am extremely upset with you at this point because I ordered you to get a device. You did not get the device, did you?
I'm sorry, I thought I was actually calling. I didn't know where to get it from.
I told you to get the device. I ordered you to get the device. You did not do anything. And now you are here on a bond violation, not to mention 4 open cases. And now you want me to just take a proverbial slap on the wrist? No. You need to understand, Mr. Musadaki, that actions have consequences. And
Yes, sir.
you not only picked up 4 cases,
I brought my dad here. He's here. Can you come up?
your dad has nothing to do with this and will not save you from this. You have 4 cases and you fail to over and over and over to comply with bond conditions. I will not accept this agreement, and I'm now revoking your bond, and you will go to jail. Goes with you. Unacceptable. Unacceptable. You need to learn that actions have
I called. I've been working.
You today go to jail.
Yeah, can we get a trial setting for Mr. Musaddiq?
100%. Happy to do it. But, you know, the 4 cases, I ordered him to get a GPS, just they didn't even get it. It's like at what point do we say when? We continually just. Ms. Mendoza, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable. That remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On March 16th, 2024, Harris County Sheriff's Office was dispatched to 514 Salma Court in Harris County, Texas, for an assault call. The complaining witness reported that her ex-boyfriend's new girlfriend, the defendant, assaulted her. The complaining witness got an email from her ex asking her to meet at his workplace in Harris County, Texas. The complaining witness arrived, and as she was getting out of her vehicle, the defendant ran up to her and started grabbing the complaining witness by the hair and punching her, causing her pain. The complaining witness was trying to clarify that her ex contacted her, but the defendant continued to strike the complaining witness and reportedly tried to gouge her eyes out. The complaining witness's ex-boyfriend was a witness and pulled the defendant off of the complaining witness. The defendant was trying to contact more people to show up and also assault the complaining witness.
Any alcohol or anything like that play a factor in it?
There's no indication of that, and I've spoke to the complaining witness and it didn't seem so either.
We have a prior assault from 2 years ago, give or take. Any of these same parties alleged in this prior assault?
Different witnesses, judge, and complainants.
Okay, Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You're also not allowed to have contact with the other witness in this case as well. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I will protect my county at all costs. Do you understand?
Yes, but
I'm not gonna, this is not a negotiation. I'm ordering you not to have any contact with either of these people. Do you understand?
yes, it's just that he's my husband though, the witness.
How old are you, ma'am?
I'm 25.
You have the ability to hire a lawyer.
No.
I can have you fill out an application. I'll take a look to see whether you're qualifying. I need to know everything about you, ma'am. I need to know how much money you make, how much money you have coming in, money in the bank, cars, stocks, bonds, mutual funds, and then we'll take a look to see whether you qualify. He's going to give you an application. I'm going to have you sign a receipt with Victoria. We'll have you take your seat in the jury box while we get your bond conditions created. Do not leave until you sign our bond conditions. All right, Deputy Miranda will give you the application.
While the defendants are, can I express some of the concerns from the complaining witness?
Okay, hold on, ma'am.
I just want to make the court aware of everything that's going on. Thank you, Judge.
Yes, of course.
I spoke to her yesterday and she told me that the defendant's family contacts her regularly and that the defendant contacted the complaining witness trying to get her to sign an affidavit of non-prosecution. And I believe it's the defendant's boyfriend's mother that's been contacting her is one of her concerns. And she states that she's been threatened civil legal action if she doesn't drop this lawsuit. And the defendant's boyfriend's mom, she relayed to me, actually reached back out to her while I was on the phone with her yesterday and was attempting to contact her. And she wanted me to get with her after this court date.
You are not allowed to have any contact, and I don't want to hear that any other parties are trying to make contact with the complaining witness. If I find that they do, it is you that will be in jail at a very high bond. Do you understand? So reach out to the complaining witness, let them know if they hear anything else from any other persons, then we'll bring them back and then we'll take care of it.
Judge, thank you.
Please, and then if you can file all those conditions.
Yes, Judge.
Good morning, Mr. Gutierrez. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's highlighted for
Thank you, Your Honor. On April 28th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a crash and made contact with the defendant and noticed a moderate odor of alcoholic beverage and red watery eyes. The wheel witness stated that he was inside of his house when he heard a loud bang outside and went out to see a vehicle trying to reverse out of his driveway with the defendant in the driver's seat. The defendant backed into the ditch and the wheel witness told the defendant to stop. The defendant hit the wheel witness's vehicle and a second complaining witness's vehicle. A law enforcement officer arrived and the defendant stated he had been drinking throughout the day. The defendant admitted to hitting both vehicles. A law enforcement officer found an empty beer can on the driver's side floorboard. The defendant was transported to the Joint Processing Center for standard field sobriety tests. A 4 out of 6 was recorded on the HGN, a 4 out of 8 on the walk and turn, and a 4 out of 4 on the one-leg stand. The defendant consented to providing a breath specimen and blew a .094 and a .103.
Okay. Any prior to WIs?
No, Your Honor.
License?
I do not have any data populating for the license field.
He does not have a driver license.
Mr. Gutierrez, number one, I'm going to find there's probable cause to go forward with your case. Number two, you're not allowed to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will put you in jail. No more PR bonds. Number three, you'll be signing an affidavit with me today. Everything I said to the other gentleman applies to you. I don't give a rat's behind what your excuse is. You do not drive. This is an affidavit that you're signing with me, promising me you're not going to drive. If you do, I can have a contempt hearing, and every time you drive, it's an offense in and of itself, punishable by an additional 6 months in jail. Do you understand?
Yes, sir.
Nothing in this life can you justify getting into a car and driving. Nothing. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria. We will have you sign a reset. After that, you'll get with Roxanne for your bond conditions, and after that, you're free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Ernesto. If he tells me he cannot get a hold of you because you're playing games, If you pick up a new case, if you become a danger.
Bennett?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just for 25, PCS, unauthorized use, and now you have an evading arrest.
A lot of those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just the presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something
This is
happens.
a turning point, and it's a powerful reminder of how seriously courts take compliance with bond conditions. What we're seeing here isn't just about the original charges anymore. It's about repeated failure to follow court orders. Legally, bond is a privilege, not a right. And when a defendant violates those terms, especially multiple times, the judge has full authority to revoke it. And that's exactly what's happening. The judge is making it clear. This pattern of behavior shows disregard for court authority. Emotionally, you can hear the frustration building. This isn't a one-time mistake. It's a repeated cycle. And that changes everything in how the court responds. Let me ask you this. At what point should a judge stop giving chances? Because in this moment, the court draws a hard line. And just like that, the consequences shift from warning to immediate custody.
Lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat.
Good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to is this on doctor?
It's on the
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand?
I do understand that.
This isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No, once you plead guilty, it stays with you forever. You never change it. If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can't talk to you about that case, right? You're telling me that it's self-defense.
A child a day?
Yeah. What do I do?
She's gonna show up.
She won't.
Guys, I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We will for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
Morning, Mr. Tolentino.
Morning.
Sir, you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully. If you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change. No drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're under probation as well. I'll make you a deal. If you do well, you get everything done quick. I'll take you off in half the time, meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
Sir.
All right, bud. Good luck to you, sir.
Thank you, Judge.
Thanks, John. Okay. Mr. Aguilar, you're charged with failure to stop and give information striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take it, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
And he was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right? It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give information.
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
you
no,
have
sir.
the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So
Sir.
just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including
property. And if I find that you're a danger to my city, I'm gonna lock you up and I'm gonna make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Tell Your Honor.
Tell me what time of night do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay, I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Chimeo.
Good morning.
Good morning.
Charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. If you ever get pulled over again, officers will see this DWI and they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, meaning once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do?
That's it.
Yes.
Is it true or untrue that you had a .15 or above breath test?
True.
I find that it's true. I'm now more than
What we
17.
witness in this courtroom is a full spectrum of judicial decision-making, from giving opportunities for reform to enforcing strict consequences when those chances are ignored. Across multiple defendants and charges, one theme remains consistent: accountability. Whether it was Mr. Patrick facing structured supervision, repeat offenders having their bonds revoked, or defendants being warned about lifelong consequences of guilty pleas, the judge made it clear that every action carries weight. This wasn't just about punishment. It was about control, prevention, and protecting the community. The court balanced second chances with firm boundaries, showing exactly how quickly leniency can turn into enforcement when trust is broken. And in the end, every defendant walked away with a clear message: comply or face the consequences.
Now more than 17 to 27 days. Give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you, sir. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe his energy status has changed since then. Can we have the court waive the DPS fee? Thank you, Judge.
Okay. You take the clerk. Please.